A traffic commissioner will decide if it is necessary to hold a public inquiry. If a public inquiry is to be held, written notice of no less than 21 days of the inquiry and where it will be held will be sent to you and to any other affected parties. Public inquiries are usually held on a weekday and may take place either at a traffic commissioner's office or somewhere near the operating center. Notice of a public inquiry will also be published in applications and decisions. However, a traffic commissioner can postpone or cancel the inquiry at any time. An inquiry will be held in public, but the legal body can stop the public, including, for example, potential competitors, from attending the parts of the inquiry where financial or other sensitive information is given. It is up to the traffic commissioner concerned to decide how to run the public inquiry. However, he must give the applicant and any objectors and representatives an opportunity to present their cases. The procedure will be explained at the start of the inquiry, which will be informal. After hearing from the applicant, objectors and representatives will make his decision based on the following evidence. Anyone putting forward facts at the inquiry must be able to prove them. Often the best way to do this is to get someone who has first-hand knowledge to appear and state those facts. Anyone who gives evidence in this way, whether he or she is the applicant, an objector, a representative, or a witness for any of these people, can then be asked questions by the other parties and by a traffic commissioner. Any evidence that is not relevant to the case will not be considered. Documents. If you are going to present documents or photographs at the inquiry, it is useful to provide several copies to avoid taking up time by passing them around. What happens at public inquiries? Before the inquiry begins, the inquiry clerk will make a note of all the people who wish to speak, so be sure to report to the clerk as soon as you arrive at the inquiry if you hope to put your case forward. A legal body will then enter the room. The inquiry clerk will announce the case by giving the name and address of the applicant, brief details of the application, i.e., the type of license applied for, and the number of vehicles involved, and the names of anyone who will be representing the applicant or giving evidence on his or her behalf. The clerk will also name any objectors and representatives present, and anyone representing them. The inquiry might then proceed in the following way. They will deal with preliminary matters, such as whether objections or representations are valid and should be heard. The applicant or his/her representative will be invited to outline his application and will be questioned about it. They will invite the objectors and/or the representatives or people appearing on their behalf to present their cases in general terms. They will then call the objectors, representatives and the applicant, usually in that order, or their representatives, to present their cases in detail. The points they make may in turn be questioned by any of the other parties and by a legal body. During the proceedings, they might ask the applicant about the effect that conditions imposed in the license might have on the business. They will then invite the objectors, representatives and the applicant to sum up the cases they have presented. No new facts can be introduced at this stage. Finally, they will consider all the evidence presented at the inquiry and either announce the decision straight away or give it in writing at a later date. Your part in the inquiry proceedings. Inquiries held by a traffic commissioner are not as formal as in a court of law, but they do follow the same basic pattern. You do not have to bring a legal or professional representative with you. However, as a traffic commissioner's decision could have serious repercussions for your business, you should consider whether a representative could help you to prepare and present your case. You must read the call-up papers carefully. If you are asked to provide information by a set date, you must do so. At an inquiry, they will first briefly summarize its purpose. If the inquiry is to consider an application for a license, they will ask you questions and may also ask any witnesses, e.g., a vehicle or traffic examiner, to give a report before making a decision. You will be able to ask the witnesses questions and answer any points that are made. If there is a representative or objector to the application, a resident, the local authority, or the police, then a traffic commissioner will probably ask them to explain the grounds for their opposition. You or your representative will then be able to cross-examine the representative or objector, who in turn will be able to cross-examine you. A traffic commissioner will give a decision only after hearing both sides of the argument. A traffic commissioner may also, at his or her discretion, allow other people who do not have a right to object but who have relevant things to say about the application to make their points at the inquiry. If this happens, you can ask them questions and reply to any points they make. If they have called the inquiry to consider taking regulatory action against your license and / or your transport manager, the vehicle examiner, traffic examiner, or anyone else who has supplied evidence will probably be asked to present evidence in person at the inquiry. You will be able to put questions to any witnesses. They will also ask you questions, and you will always have the right to answer them before a decision is made. When a traffic commissioner is considering whether you satisfy the requirements of financial standing, a financial assessor may be asked to sit in the inquiry and examine any evidence that you present. The financial assessor may also ask you questions during the inquiry, and a legal body will consult the assessor before making a decision. Please note, you will normally be able to operate under an existing license until the appeal is heard.